Well, hopefully this does the trick. I've disconnected myself from the network altogether, and I'm just running off Wi-Fi. I'm running an iPad off the network. So, should be able to continue this and hopefully not be interrupted again. If so, I'm going to lose my ever-lipping mind. What up, Tracy? Okay. Oh, what a pain. I swear it feels like this is being done maliciously. Of course, I can't prove it. Hey, Kathy. Oh, I'm sure these group admins are tired of seeing my post. Okie doke. I think that's it. We got one person watching. So, we're going to get back to it. We're going to get back to reading the regs. Tired of dilly-dallying around. Okay. The bottom of page 47, line 28. So we got section 12, section 8012 of title 63. A, there is hereby created and authorized a medical marijuana patient license. Here we go, the meat of it. A person in possession of a state-issued medical marijuana patient license shall be entitled to the following rights and responsibilities subject to the provisions of this act. To consume medical marijuana and medical marijuana product legally without restriction on the type or form of medical marijuana product except as it pertains to minor children patients pursuant to this act. 2. To legally possess up to 3 ounces of marijuana on their person. 3. To legally possess up to 6 mature plants. 4. To legally possess up to 6 immature plants. 5. To legally possess up to 1 ounce of medical marijuana concentrate. 6. To legally possess up to 72 ounces of edible medical marijuana infused products. And 7. To legally possess up to 8 ounces of medical marijuana in their residence. 8. The right to possess the marijuana products set forth herein are cumulative, and a duly licensed individual may possess at any one time the totality of the items listed herein and not be in violation of this act so long as the individual holds a valid medical marijuana license or caregiver's license. C. Municipal and county governing bodies may enact medical marijuana guidelines allowing medical marijuana patients or caregivers to exceed the personal patient or caregiver limits set forth in this section. Municipal and county governing bodies may not enact medical marijuana guidelines which restrict or interfere with the patient or caregiver rights to possess, purchase, cultivate, or transport medical marijuana within the legal limits. D. Possession of marijuana amounts less than identified in B1-7 above by persons who can state a medical condition that can be treated with medical marijuana but not in possession of an Oklahoma medical marijuana patient or caregiver's license shall be subject to the issuance of a citation with a personal a recognizance bond and treated similar to a traffic ticket that upon a conviction or plea of guilty may be subject to a fine not to exceed $400. Possession of marijuana in this instance shall no longer constitute a misdemeanor offense. E. Qualifying patient licensee must be an Oklahoma resident and be 18 years of old or older, provided, however, a special exception will be granted to an applicant who is under the age of 18 or a younger pursuant to this act. Any additional institution, public or private, shall not refuse to enroll, discipline, expel, or otherwise penalize a qualifying patient or caregiver licensee solely based upon their status as a medical marijuana patient or caregiver, unless failing to do so would imminently cause the school to lose monetary or licensing-related benefit under federal law or regulations. What that is talking about is schools that are, or any entity that is federally funded. Those guys, you can't, in those particular instances, and that's protecting you from federal law. G. Any landlord shall not refuse to lease to or shall not otherwise evict or penalize a qualifying patient licensee solely based upon their status as a medical marijuana patient, unless failing to do so would imminently cause the landlord to lose a monetary or licensing-related benefit under federal law or regulations. However, a landlord may charge a medical marijuana patient a deposit not to exceed $250 to cover any anticipated cleaning or damage that may occur to the property as a result of the patient growing or smoking cannabis in the resident. Okay, so like a smoker's deposit. H. Nothing in this section prohibits a residential or commercial property or business owner from prohibiting the consumption of medical marijuana or medical marijuana products by smoke or vaporizing on their premises, within the structures of the premises, or within 10 feet of the entryway to the premises. However, a medical marijuana patient shall not be denied the right to consume or use other medical marijuana products which are otherwise legal to do, do not involve the smoking or vaporization of cannabis when lawfully recommended pursuant to this act. So, you can have your edibles and oils, but not your smokables or vapes on residential or commercial property. I. The status and conduct of a qualified patient who acts in accordance with this act shall not by itself be used to restrict or abridge custodial or parental rights to minor children in any action or proceeding under the jurisdiction of a family or juvenile court. Yes, yes, yes. There is no presumption of neglect or child endangerment for conduct allowed under this act unless the person's behavior violates the terms of this act. Only when a court finds that the licensee's behavior caused by the use of medical cannabis created an immediate and imminent threat to the safety of the child, which a court determines will cause an irreparable harm to the child, shall the medical marijuana licensee holder's custody, visitation, or parenting time be affected. Such finding of a court must be based upon an independent report, including but not limited to a police report or a report from the Department of Human Services that demonstrates that the child in surroundings which endanger the safety of the child, and that if such conditions continue, the child would likely be subject to irreparable harm. If there is no such report, the court must be presented with a notarized affidavit from an individual with personal knowledge of that the child and its surroundings which endanger the safety of the child and the continued custody, visitation, or parenting time between the medical marijuana licensed holder and the child would cause irreparable harm to the child. The purpose of this paragraph is to prevent child abuse and neglect, not to create a cause of action for the removal of a child from a home, or to limit custody, visitation, or parenting time based on the appropriate and legal use of medical cannabis. Good. J. A medical marijuana patient or caregiver licensee shall not be denied a state-issued professional license, certification, benefit, including but not limited to Sooner Care, Women, Infant, and Children, WIC, temporary assistance for needy families, TANF, or other such low-income assistance programs unless prohibited by federal law based solely on their status of medical marijuana patient or caregiver licensee. Neither shall a patient or caregiver licensee face suspension or disciplinary action from the authority granting said professional license or certification based solely on their status as a medical marijuana patient or caregiver license. Good. K. A medical marijuana patient or caregiver license shall not be denied the right to own, purchase, or possess a firearm, ammunition, or firearm accessories based solely on their status as a medical marijuana patient or caregiver licensee under state law. No state or local agency, municipal or county governing authority shall restrict, revoke, suspend, or otherwise infringe upon the person's right to own, purchase, or possess a firearm, ammunition, or firearm accessories, or any related firearm license or certification based solely on their status as a medical marijuana patient or caregiver license. Good. Another really good section that protects our rights. L. A medical marijuana license holder or designated caregiver in actual possession of the medical marijuana license card shall not be subject to arrest, prosecution, or penalty in any manner or denied any right or privilege under Oklahoma State, municipal, or county statute or ordinance, including without limitation a civil penalty or disciplinary action by a business, occupational or professional licensing board or bureau for the medical use of marijuana in accordance with the medical marijuana program. No person holding a medical marijuana license may be prohibited from holding a state-issued license of any kind, including but not limited to driver's, medical, license to practice law, conceal and carry, cleats, or any other professional license by virtue of such person being a medical marijuana patient, caregiver, occupational, or business license holder. M. For the purposes of medical care, including organ transplants or pain management, the authorized use of marijuana by a medical marijuana license holder must be considered the equivalent of the use of any other medication under the direction of a physician and shall not constitute the use of an illicit substance or otherwise disqualifying a registered qualifying patient for medical care. N. Blowing through them. In, we are at the very top of page 52. A person shall not be subject to arrest, prosecution, or penalty in any manner or denied any right or any privilege under Oklahoma State, municipal, or county statute or ordinance, including without limitation or civil penalty or disciplinary action by a business, occupational or professional licensing board or bureau, including but by, it needs to be but, that's another typo, line 5, page 52. Including but not limited to driver's license, medical licenses, law license, conceal and carry license, cleat certification, or any other license for providing a qualifying patient or designated caregiver with marijuana paraphernalia for purposes of facilitating the medical use of marijuana by a qualifying patient. O. A person shall not be subject to arrest, prosecution, or penalty in any manner or denied any right or privilege under Oklahoma State, municipal, or county statute or ordinance, including without limitation a civil penalty or disciplinary action by any business, occupational, or professional licensing board or bureau, including but not, and again by needs to be but, that must have been copy and pasted, including but not limited to driver's license, medical license, law license, concealed carry, cleat, presence of vicinity of medical use of marijuana as allowed under the medical marijuana program, or for directly assisting a medical marijuana licensee with the medical use of marijuana. P. A person shall not be subject to arrest, prosecution, or penalty in any manner or denied any right or privilege under Oklahoma State. All the same stuff we've been going through. They can't have any legal action brought against them at all. For obtaining assistance for an individual suffering a medical emergency due to medical marijuana consumption. Q. A government medical assistance program shall not be required to reimburse a person for costs associated with medical use of marijuana unless federal law requires reimbursement. That is a statement for the future. That's put in there so that when marijuana is descheduled from Schedule 1, and they start putting their regulations on it, that would cover that. So I like that. R. Oh, this is a long one. For purposes of employment, terms of employment, decisions to hire, discipline, suspend, or terminate employee or independent contractor, it shall be discriminatory for anyone, A, to fail or refuse to hire, to discharge, or otherwise discriminate against an individual with respect to compensation or the terms, conditions, privileges, or responsibilities of employment because of their status of a medical marijuana patient or caregiver licenses, or B, to limit, segregate, or classify employer applicants for employment in a way which would deprive or tend to deprive an individual of employment opportunities or otherwise adversely affects the status of an employee because of their status of a medical marijuana patient or caregiver license. C, To fail to refuse to hire, to discharge, or otherwise to discriminate against an individual based solely on the results of a drug screening showing positive THC and its metabolites, unless workplace impairment is further evaluated through an employee impairment detection system, and the position or role has a generally accepted industry standard that prohibits the use of other legal forms of medical treatment which would impact the employee's performance in a manner substantially the same as medical marijuana, i.e. opiates, alcohol, or other legal substances. During the course of the employment or contract or the professional or contractual duties involved include the handling, packaging, processing, storage, disposal, or transport of hazardous materials, the operation, use, or maintenance of motorized vehicles, the operation of heavy equipment or machinery. I-4 or I-5, which is 4, the extraction, compression, processing, manufacturing, handling, packaging, storage, disposal, treatment, or transport of potentially volatile, flammable, combustible materials, elements, chemicals, or any other highly regulated component. Unless the employer can demonstrate that accommodation for the marijuana patient or caregiver license would impose an undue hardship on the operation of the business of such employer or would jeopardize an employee's contractual status, professional licensure, compliance with federal law. Holy crap, that's a whole lot to say that they're protecting you at work. Unless you're an idiot and smoke up and go drive a forklift. 3. Shall reserve the right to discriminate against, refuse to hire, suspend, discipline, or terminate an employee or independent contractor if the person is impaired while at the place of employment or during the fulfillment of employment or contractual obligations. The presence of THC metabolites in the employee drug screening should not be used by an employer or I'm getting to that point, guys. Dispositive for workplace impairment. The standard for assessing impairment for performance of work requirements while under the influence of medical marijuana shall be the same or substantially similar to the standards for assessing impairment for the performance of work regulations while under the influence of similar substances such as alcohol, opiates, or other such legal substances. S. An employer shall not be required to accommodate the ingestion of medical marijuana in smokable or vaporized format in a workplace. Again, this is just all the same smoking rules that we see with tobacco implemented as well. That's what we need. So T. If an employee tests positive for intoxication or uses an illegal controlled substance or a legal controlled substance, including medical marijuana or medical marijuana product that is used in contravention with a treating physician's orders within 24 hours of being injured, he or she shall not be eligible to receive benefits under qualified employer's benefits plan pursuant to 85A 2017 section 209. It shall be the employer's burden to prove that the employee used medical marijuana in contravention of a treating physician's orders within 24 hours of being injured in order to retain exclusive remedy, enjoy immunity from common law negligence claims. An employee shall be entitled to receive benefits under a qualified employer benefit plan if the employee can prove by a preponderance of the evidence that the acts described in this section were not the major cause of an injury. Whew. All smokable, vaporized, vapable, and e-cigarette medical marijuana product ingested or smoked by a patient license holder are subject to the same restrictions for tobacco, which is what I just said and is exactly right. Smoking in public places and indoor workplaces Act. There you go. And we're at section 13, and I'm worn the fuck out. We're only 7 more pages into it. 55. We're at section 13. I'm going to take a quick break. And I haven't lost you guys, have I? I mean, at any point, have I lost you guys? Oh no, I'm out of cigarettes. That's bad. 2 minutes, I'll be right back. definitely gulps. Kathy gulps a lot. I must have missed that joke. I'll go back and read it later. Nope, don't think that. So far, so good. I expect the rest to sound as good when Billy reads it as it did when I read it. I like it to go over, twice. This first time, I'll read it word for word for the most part. Well, when I go back over it the next time, I'll literally scan over it in about an hour. And just go back over and remember. And just kind of spur my memory as to what I already read over, and that's when I really start to learn about things, is that second scan. But I've caught a lot of things that are definitely good so far. Again, I only have that one concern with the caregiver. I still haven't found any other. I'm 50 flipping pages, 57 or whatever pages into it, and no concerns for the most part, except that one. I am really interested in the whole variant thing and how easy that would be to, depending on what it was, get approved. I like the idea. That's not something I ever would have even contemplated. I mean, it makes sense why it's there, but that's why these super smart people like Gideon here are the ones that are writing this stuff and not me. So, shall we get back at it for a little bit, guys? How far do we want to go tonight? Shit, I'm only a quarter of the way through. 55 pages of 202. I know, right, Tracy? We're not even halfway through yet. So, let's see how long section 13 is before I start reading it. Yeah, it's another 4-pager or 5-pager. There's a lot of those. Lots of those. Well, let's see here. Section 13. Wow, I mean, you did have, 27 pages of definitions? I don't even want to start reading this. Fuck my life. Right, Tracy? I know. Alright. Section 13. We're at the third paragraph down on page 55, line 8, section 13, section 8013 of Title 63. A. Pursuant to 63 OS 420A, the department shall make available on its website and all health department offices in paper or printed form in an easy-to-find location an application for a medical marijuana patient license, caregiver license, and a temporary medical marijuana patient license. B. A written or digital certification from a physician as defined in this act shall be submitted with the application for a medical marijuana patient license pursuant to this act. The department may contact the physician to verify the applicant's need for a medical marijuana card. The physician may only issue the written certification using accepted standards a reasonable and prudent physician would follow while recommending or approving any medication. C. The application fee for a patient license shall be $100. Individuals who can demonstrate their status as a disabled veteran or coverage under Medicaid, Medicare, or Sooner Care will pay a reduced application fee of $20. The methods of payment, as determined by the department, shall be provided on the website. However, the department shall ensure that all license applications have an option to submit the license application and payment by means other than solely by submission of the application and fee online. That's exactly what we need. I can't tell you the amount of people that have come out and lost their mind about that. Well, I can't do it online. There's your answer. The patient license is valid for up to 2 years from the date of issuance unless the qualifying physician's recommendation is terminated pursuant to this act or revoked by the department. The department shall promulgate rules defining the requirements for verification of an applicant's status as a disabled veteran or demonstrating coverage under Medicaid, Medicare, or Sooner Care. D. The application for a patient license shall be on the department-issued form and shall include, at a minimum, 1. The application's first name, middle name, last name, and suffix if applicable. 2, the applicant's residence, address, and mailing address. If the applicant proves Oklahoma residence but does not have a fixed residential address, then the address where the applicant can receive mail. 3, the applicant's date of birth. 4, the applicant's telephone number and email address. 5, the signature of the applicant attesting to the information provided by the applicant is true and correct, and pledging the applicant will not divert medical marijuana to any individual or entity that is not lawfully entitled to possess medical marijuana. That's all great. I want to go back up to 2 real quick. The applicant's residence, address, and mailing address. If the applicant proves Oklahoma residence but does not have a fixed residential address, then the address where the applicant can receive mail. Okay, so guys, what's that saying is that's basically allowing homeless people and maybe mentally ill people that are going to be able to get their license sent to them and not have it restricted by the fact that they don't have a permanent address. Whoever put that in there was definitely thinking. That's really good. Okay, so we did 5. 6, the date the application was signed. E, an application must be submitted within 30 days of the applicant's signature or it will be rejected by the department. F, the following documentation shall accompany the application or the application will be rejected. 1, documents establishing the applicant is an Oklahoma resident. Sufficient documentation of proof of residency shall include one of the following: an unexpired Oklahoma driver's license, an unexpired Oklahoma identification card, a voter identification card, a utility bill for the calendar month preceding the date of application, excluding cell bills and internet service bills, a residential cable bill, which includes cellular telephone and or internet service, shall qualify as a utility bill under this section. E, a residential property deed to property in the state of Oklahoma. F, a current rental agreement for residential property located in the state of Oklahoma. 2, documents establishing proof of identity as established in this act. Proof of identity shall be established through submission of a color copy of digital image of one of the following unexpired documents: front and back Oklahoma driver's license, front and back Oklahoma ID card, a U.S. passport or other photo identification issued by the U.S. government. D, certified copy of the applicant's birth certificate for minor applicants who do not possess a document listed in subsections A, B, or C. E, a tribal identification card, a proof for identification purposes by the Oklahoma Department of Public Safety. 4, a digital photograph of the applicant. The department shall promulgate rules defining the type, size, resolution, and medium of transmission for the digital photograph. Right, Tracy. G, patient licenses may be issued for applicants under the age of 18. Minor patient licenses are valid for a term of 2 years. Upon attaining the age of 18, the department shall provide a form for the minor whichever occurs first, unless either of the physician's recommendations are terminated pursuant to this act, or there are less than 90 days remaining in the recommendation period from when the physician first issued the recommendation. If there are less than 90 days remaining in the validity of the minor's patient license, then the minor patient shall submit the application for a renewal of his or her medical marijuana license as an adult licensee and obtain the necessary recommendations from a physician for an adult medical marijuana license renewal. The minor may begin the process of obtaining the necessary exams and paperwork for renewal 30 days prior to obtaining the age of 18. Is that like subsection G? There's no marking for it. Okay, minor patient licenses shall have a grace period of 90 days from the date of their 18th birthday to allow the department time to process the conversion of the minor patient licensee to an adult, conversion of the minor patient's license to the adult medical marijuana license, provided they can demonstrate that they have initiated the process to convert their minor patient license to an adult patient license. Minor patient, by and through their designated caregiver, may begin the process of converting their license to an ordinary medical marijuana license no more than 30 days prior to their 18th birthday. Minor patient license applicants shall submit the same documentation as required by this section for patients and the following. 1. The The application shall require the recommendation by 2 physicians dated within 30 days of each other, and both recommendations must state the same diagnosis for which the recommendation of medical marijuana or medical marijuana product is made. The application must be completed listing the minor as the applicant, but shall also include the same information as is required in the section for minors, parents, or legal guardians. 3. Proof of residency and identity information required shall be provided for the minors, parents, or legal guardians. 4. A digital photograph pursuant to this act and subsequent rules promulgated thereunder shall also be included of the minors, parents, or legal guardians. 5. If the person submitting the application on behalf of a minor is the minor's legal guardian, a copy of documentation establishing the individual as the minor's legal guardian must be submitted. What happens if the minor that turns into an adult is incapable of making their own decisions? Tracy, I exactly understand what you're talking about there. That, I think, is going to fall under the caregiver part. If I'm not wrong, in terms of the doctor recommending that the caregiver that they have a caregiver. I would assume for people that are mentally incapable of taking care of themselves. So that would be my guess there. That it would be you would have to get a caregiver's license not just as the parent anymore. Yeah, the caretaker. That's the people that can at this point. What do you mean? Giver story? The caretaker? No, that's what it says. So to be a caretaker, it has to be for a patient that is recommended by a doctor, including, or in this act they talk about that it has to be recommended by the physician, that the person is homebound or otherwise unable. So if they're unable, then they should be able, if they're mentally incapacitated and unable, they should be able to get that doctor sign off to be able to have a caretaker take care of that for them. So grow for them or go buy for them. Okay, moving on. 5. If the person submitting the application on behalf of the minor is the minor's legal guardian, a copy of documentation establishing the individual as a minor's legal guardian must be submitted. 6. The signature and date of each parent or legal guardian must be included in the application. In the event one of the parents or legal guardians has abandoned the minor or is otherwise unavailable, a notarized affidavit stating the reason the parent or legal guardian cannot sign, except in the case of refusal or disagreements, is sufficient if approved by the department. 7. An attestation by the parent or legal guardian that the information provided in the application is true and correct must be included on the application. And 8. The minor applicant is not required to submit any documents listed herein. H. The Department of Health review the medical marijuana patient approval application, approve or reject application, and mail the approval, rejection, or status update letter to the applicant within 14 days of receipt of the application. Applicants who are approved shall be issued a patient license, which shall act as proof of his or her approved status and be added to the medical marijuana use registry established pursuant to this act. Caretaker used to take people away. Wait, what? I should do voiceover work. Thank you, Alex. Okay. Anyway, I. If the department rejects an application for a medical marijuana patient license, the letter to the applicant shall state the reason why the application was rejected. Applications may only be rejected by the department due to an applicant not meeting the standards set forth in this section or the improper completion of an application. Upon receipt of a rejection, the applicant may resubmit an application correcting any defects which caused the rejection within 15 days of mailing of the notice or rejection without paying a new application fee. Okay, so if you screw up on the application, you've got 2 weeks to get it in without having to pay the fee again and get it fixed. J. Licenses issued to patients, caregivers, and temporary patient licenses shall contain the following. 1. Digital photograph of the license holder. 2, the name and date of birth of the license holder. 3, the city and county of residence of the license holder. 4, the type of license. 5, the date of license expires, and the unique 24-character control number assigned to the license holder. K, approval or rejection letter shall be sent to the applicant in the same method the application was submitted to the department. L, the department shall only keep the following records for each approved patient license. 1, a digital photograph of the medical marijuana patient license. 2, the expiration date of the license. 3, the county where the license was issued. And 4, the unique 24-character identification number assigned to the patient licensees. The department shall ensure all application records submitted in accordance with this act are sealed to protect the privacy of medical license applicants and patients unless provided otherwise in this act. Section 14, this is going to talk about physicians, what they can and can't do. That's not a super long section. It's like 3 pages, 2.5 pages. We're now at the bottom of page 60. Section 14. Section 14, bottom of page 60, line 29. So Section 8014 of Title 63. A, only licensed Oklahoma physicians as defined at Title 59 may provide a medical marijuana recommendation for a patient medical marijuana license under this act. B, all applications for a medical marijuana patient license must be recommended by Oklahoma physician according to the accepted standards a reasonable and prudent physician will follow when recommending or approving any medication. C, physicians who have completed their first residency do not meet the definition of physician under this section, and any recommendation for a patient medical marijuana license will not be processed by the department. D, a licensed medical professional may apply for a letter of need to the department describing the lack of recommending physicians in their geographic area, requesting special authorization to make medical marijuana recommendations. That, I was just talking about that with somebody today. I don't remember who, but I specifically remember talking how this was actually part of the whole caregiver issue, is that if you got people in the boondocks in Oklahoma, say Boise City or like maybe, well, not Poto, they'll end up being a dispensary or something there, but a tiny little town, nowhere, slap out, places that don't have, that don't really have much of a town, but they definitely have a population. Well, those places are, it's going to be very difficult for somebody to drive 2 hours to the city or an hour and a half to the closest town to be able to get it. So the fact that they've addressed that by allowing other people besides the specific doctors to be able to recommend in those areas, I think that's a really good foresight. Hold up, that's got to be wrong. C or D, a licensed medical professional may apply for a letter of need to the department describing the lack of recommending physicians in their geographic area, requesting special authorization to make medical marijuana recommendations. So a licensed medical professional. So it still has to be somebody that's a medical professional, but it doesn't necessarily say they have to be a doctor. So I'm thinking maybe in that area, maybe a nurse or a PA or something. But again, that would have to be something that would be determined by this board, this group. So E, no physician may be unduly stigmatized or harassed by any state, council, or municipal authority by any employer, contractor, or professional licensing agency or authority for issuing a medical marijuana recommendation for a patient. Oh, one before that. Which one? After they are a resident past whatever, doesn't that make them a doctor? You're asking the wrong person. You're gonna have to ask somebody else about that. Or hey, Randy Whitekiller, you on here, brother? Why don't you answer that for us? E, no physician may be unduly stigmatized or harassed by a state. Okay, we just read that. F, no physician shall be subject to arrest, prosecution, or penalty in any manner or denied any right or privilege under Oklahoma state, municipal, or county statute or ordinance, including without limitation a civil penalty or disciplinary action by the state board or medical licensure and supervision by any other businesses. Business, occupation, or professional licensing board or bureau solely for providing a written medical marijuana recommendation for a patient or for monitoring or treating patients who are medical marijuana license holders. The provisions of this subsection shall not prevent the relevant professional licensing boards from sanctioning a physician for failing to properly evaluate the medical condition of a patient or for otherwise violating the applicable physician-patient standard of care. G. The physician or licensed healthcare professional may administer medical marijuana or medical marijuana products to a licensed patient who resides in a licensed healthcare facility if the administration of pharmaceuticals is within the scope of practice of the licensed healthcare professional. Administration of medical marijuana under this subsection may not take place in a public place as defined herein. If the medical marijuana administered under this section is a smokable format, adequate ventilation must be provided. H. Nothing in this subsection requires 1. A licensed healthcare professional to administer medical marijuana or medical marijuana products. So you can't force a doctor to recommend a medical marijuana. 2. A licensed healthcare facility to make accommodations for the administration of medical marijuana. So again, we can't force the hospitals or any other clinic to accept medical marijuana recommendations. I. Recommending medical marijuana for a patient is at the professional discretion of the physician, which shall be exercised in accordance with the accepted standards. A reasonable and prudent physician would follow in recommending or approving any medication. The indication, appropriateness, and safety of the recommendation should be evaluated in accordance with the current standard of practice. There shall be no restrictive qualifying conditions determining a patient's ability to receive a medical marijuana recommendation from their physician. Let me read that one more time. There shall be no restrictive qualifying conditions determining a patient's ability to receive a medical marijuana recommendation from their physician. J. A physician may regularly assess the response of the patient to the use of medical marijuana and overall health and level of function. As medically appropriate, this assessment should include the efficacy of treatment to the patient, the goals of the treatment, and the progress of those goals. K. A physician may file a registration with the department as recommending physician on a form prescribed by the department. L. A physician registration must include at minimum all of the following. I. The physician's full name, business address, professional email address, telephone numbers, and if the physician owns or is affiliated with a medical practice, the name of the medical practice. 2. The physician's medical license number. 3. A certification by the physician that states that the physician's Oklahoma license to practice medicine is active and in good standing. M. Accepted standards a reasonable and prudent physician shall follow when recommending medical marijuana to a patient includes the following. 1. Establishment of a physician-patient relationship in which physician has responsibility for the assessment, care, and treatment of the patient's medical conditions or an aspect of the patient's medical condition in accordance with the acceptable standard of care for patient care and treatment within the community. Nothing about the acceptable standards of care shall be deemed to require that the physician and patient had a pre-existing relationship prior to the examination which resulted in the recommendation of medical marijuana, so long as the physician would otherwise be able to recommend or prescribes misspelled, a similar substance such as opiates or other pain management. Bingo! That's a really important section. Nothing about the acceptable standards of care shall be deemed to require that the physician and patient had a pre-existing relationship. That means you can go in to any doctor that will see you and that will recommend, and they will be able to do that, which is the way a lot of them are setting up now, so it's good that that's in there. 2. Documentation of an in-person medically responsible assessment by the recommending physician of the patient's medical history and current medical condition, including physical examination within 90 days of the application for medical marijuana patient license. Telemedicine examinations are prohibited when making a recommendation to a patient for medical marijuana. 3. Optional diagnosis of a medical condition. In the physician's opinion, the patient is likely to receive therapeutic or palliative benefits from the medical use of marijuana to treat and alleviate the medical condition. 4. Discussion of the risk and benefits of the use of medical marijuana with the patient. to include the potential for adverse effects for children and young adults, the variability of medical marijuana and medical marijuana product preparations, and a warning not to operate heavy machinery or a motor vehicle while using medical marijuana. 5. Provisions of follow-up care and management of the patient's medical condition for which use of medical marijuana is recommended, including any follow-up examination necessary to determine the efficacy of medical marijuana for the patient's medical condition as determined by the recommending physician. All recommendations for medical marijuana should but are not required to include a review by the physician at least annually of the necessity of the medical need for the continuing recommendation of medical marijuana. 6. Maintenance of accurate and complete medical records. 7. Physicians are prohibited from issuing a recommendation for approval of a patient license to themselves, their family members of the first or second degree, their co-workers or employees. And 8. A physician who recommends use of medical marijuana shall not A. accept, solicit, or offer any form of pecuniary remuneration from or to a caregiver licensed MMB, or offer a discount or any other thing of value to a patient who uses or agrees to use a particular caregiver or dispensary. No favoritism. Lots and lots of that in this act. B. Examine a patient for the purpose of recommending medical marijuana at the same physical address as a dispensary. Wait, examine a patient for the purposes of recommending medical marijuana. Oh yeah, they can't do it at the dispensary, of course. 9. If after a physician completes a follow-up examination and review pursuant to this section and determines the continued use of medical marijuana by the patient no longer meets the standards set forth in this act, the physician shall notify the department. And that brings us to section 15. We're at the very bottom of page 64. And we're not even a third of the way through it. Or I guess yeah. We're right at a third of the way through it. Holy crap. No doctors in dispensaries. Exactly. Hope they get it. Oh, nice. Way to go, Kathy. Doctor in Guyman stepped up. Rocket. I got more doctors in Guyman than we do in Oklahoma City. Oh. You guys. I'm worn out. We're only on page 65. 64. About to be on page 65. What is this section 15? Caregiver. Oh, this is about caregivers. This is going to be an important one. Let's see how long this one is. Oh, it's only a page and a half. Okay, well in that case, we'll read this. Then we're going to cut this video. And either later tonight or tomorrow morning, I will go back over more. It'll probably be later tonight. You guys know me. Alright, section 15. We're at the bottom of page 64. Line 31. Section 8015 of Title 63. A. There is hereby created a caregiver license for qualified caregivers of a medical marijuana patient license holder. The caregiver license shall provide the caregiver the same right as the medical marijuana patient license holder, including the ability to possess marijuana products, and mature and immature plants pursuant to this act, but excluding the ability to use marijuana unless said caregiver has a medical marijuana patient license. Caregivers shall be authorized to deliver marijuana and products to their authorized patients. Applicants for a caregiver license shall submit the following to the department. 1. Proof that the applicant is the designee of the medical marijuana patient license holder. 2. Proof that the caregiver is 18 years of age or older in accordance with the standards set forth in Section 13 of this Act. And 3. Proof that the caregiver is an Oklahoma resident in accordance with the standards set forth in Section 13 of this Act. B. Applications for a caregiver license for those providing services to patient license holders may accompany the original patient applications as set forth in this Act or may be made at any time during the term of the patient license. C. Only one caregiver license shall be issued for each patient license issued except in the case of a patient applicant who is under the age of 18, where two parents or legal guardians may be recognized as the minor's caregivers. In addition, one further caregiver, so up to 3 for minors. A licensed medical professional may be designated for an additional caregiver for a licensed patient beyond the limits set forth in this paragraph. Caregivers, that's interesting. Caregivers for minor patients with more than one caregiver may not collectively exceed the possession limits for each patient pursuant to this act. Any variance from the number of patient licensees per caregiver shall be evaluated by the department pursuant to this act. D. The caregiver application shall be made on a form provided by the department and shall include the following. 1. All information and documentation for the caregiver required under the patient license application, except there shall be no medical certification from an Oklahoma physician. 2. A fee in the amount of $50 shall be submitted by the caregiver applicant at the time of the submission of their application. The caregiver application and license fee shall be reduced to $20 if the caregiver establishes that they or their licensed patient are a disabled veteran or recipient of a Medicaid, Medicare, or Student as determined in this act. 3. A signed, dated, and notarized attestation from the patient license holder or patient applicant appointing the caregiver as their designee under this provision. If the patient license holder is incapacitated, a durable medical power of attorney or a court order for guardianship may be submitted, and the person appointed to act under the document may execute the notarized statement. There you go. There's your answer right there, Tracy. 3. A signed, dated, and notarized attestation from the patient license holder or patient's applicant appointing the caregiver as their designee under this provision. If the patient license holder is incapacitated, a durable medical power of attorney or a court order for guardianship may be submitted, and the person appointed to the act under the document may execute the notarized statements. And if the patient is a license holder, the unique patient control or 24-digit number shall be included in the application. So there you go. For mentally incapacitated, right there. If the license holder is incapacitated, a durable medical power of attorney or a court order for guardianship. Okay, E. An individual caregiver shall be limited to a designation as a caregiver for no more than 5 patients license holders if the caregiver is exercising the marijuana cultivation rights of licensed patients as prescribed by this act. So if you've got 5 patients, you can have no more than 30 flowering plants and 30 immature plants if you're going for 5 people. F. A caregiver license for a specific patient shall be withdrawn for any patient that provides written or electronic notification to the authority on the authority provided form or their wish to withdraw the caregiver's authorization. This withdrawal shall not be subject to appeal. Upon the death or revocation of authorization of a patient for a caregiver, the caregiver may transfer any unused marijuana, medical marijuana, or products to another licensed patient. A caregiver license may not extend beyond the expiration date of the underlying patient license, regardless of the issue date. Okay, that all makes sense. I. A caregiver may cultivate the immature or mature plants of the individual for whom the caregiver has been designated to act, provided that the caregiver must still comply with any other requirements regarding the right to cultivate the marijuana at a home or location. And now we're on the page 67 and section 16, and I'm going to take a break. I just got completely booted out. Booted out of what? Here? Gotta love it. Alright, guys. Where am I at? 55 minutes. Yeah, I kind of like to keep these to about an hour apiece. They just become way too lengthy and hard to navigate when they're longer than that. So we're out for now. We'll probably be back later tonight. Hopefully, we'll make it to page 100 and we'll make it halfway through. Peace, guys. Thanks for watching. Billy D out.